be the respondent's argument. That the first point of clarification that we really, I do want to impress upon the court is that the SIU has never argued that the department was obliged to approach the suppliers in Annexure A. It is not a steadfast obligation. We've never made that argument. The argument that we've made is that the department needed good reason, or it could not ignore the suppliers in Annexure A. And there's no direct authority for that point, milady, that much is true. But it follows as a matter of first principles and interpretation. It would be irrational for a government department to completely ignore a list of suppliers compiled by Treasury, vetted by Treasury in the context of an emergency, ignore those suppliers, and instead opt, without more, for a list of suppliers handed to them by the person who's ultimately to benefit from the tender process, by in this case, Mr. Buthelezi, on behalf of Santaco. That's the argument. Depart from Annexure A to ignore those suppliers. And on the facts of this case, lady, you're frozen on my screen. I'm not sure if I've lost you.
We have lost the judge. Just a minute. We seem to be struggling with connection today.
Can you hear me now? Am I back?
I can hear you. So I don't know where you lost me, my lady, but the point that I was making is that the department needed a rational basis. It needed a reason to ignore those suppliers listed in Annexure A, and there was no reason. They just went for the suppliers given to them by Santaco. That's the argument. It's not firm duty. It's not if you don't go for them, your decision's unlawful. But it's if you are not going to go for them, if you're not going to go for the suppliers in Annexure A, you need a reason. You need rational basis. There was none in this case. That's the first clarification point.
But the department said it did consider suppliers on the list and they didn't have stock. Isn't that a rational reason?
I'm grateful for you to raising that, because that's an argument C squared makes, and they say they rely on Mr. Villiers' evidence in this regard. But I won't take the court there. I'll just give the court the reference, and the reference is on case lines 012-10. And when when the tribunal goes to that reference, it will see Mr. Villiers never says that she approached other suppliers. She just mentions that she looked at the Annexure A, saw the lead times, and without contacting anyone, decided those lead times were too long. That's what Mr. Villiers says. There's no evidence and no suggestion on her part that those suppliers were actually contacted. And with respect, the record shows all the email trails. There's all this correspondence before this tribunal between the department and all these suppliers. There is not a shred of evidence to suggest that any other supplier, other than the respondents and several others who were disqualified who are irrelevant, were contacted. There's nothing. So that's the first clarification point on the requirements in Instruction Note 8. The second are the SARPA requirements. Now, I don't mean to take the court through that in much detail. I just want to refer the court to paragraph 62 of our heads of argument. That case lines 01325. And what we do there is we make the legal point, and I submit we didn't need to make this point in our founding affidavit because it's purely a statutory interpretation point. We make the point there that there are various regulations promulgated by the Department of Health which required registration for suppliers of medical devices. And we submit that medical device comfortably covers hand sanitizers because it's a instrument, apparatus, implement, machine, appliance, implant, reagent, software, material, other similar articles.
I don't want to sound rude. I do not want to sound rude, right? But what I would benefit from is a clarification, not a rehash, because so far all I'm hearing is a rehash.
So milady, the point I was getting
to clarify, anything you'd like to respond further on, please don't state what has been stated. It doesn't assist me at all.
I apologize, my lady. The clarification I was getting to is the conversation began with a question concerning the exclusion notice. And there was a concern that the exclusion notice doesn't apply.
The definition of a medical advice.
Yes.
I've heard your case is that medical device as defined includes hand sanitizer, right?
Yes. Yes.
Anything further? That's your case.
That is the case. And I understand the tribunal that if you're with us on that point, then you're with us on the following point, that the respondents needed to be registered with SAPRA.
If I'm not with you, because what remains is a decision, right? I've heard you.
Yes. And all
is there any further submission you'd like to make?
Just paragraph 68 of our heads, it sets out the licenses notice. And that notice requires all suppliers of medical devices to be registered with SAPRA. That's the point, my lady. And that is the point. It's got nothing to do with the exclusion notice. That's the key regulation. That regulation was not before this tribunal in the Free State matter.
ShopRite Checkers that sold sanitizers is registered with SAPRA, right? That's how bizarre. That's how bizarre. Engine garages that sold sanitizers registered.
Lady,
the number of entities, the variety of entities that sold hand sanitizers, not sanitizers that are used in a medical setting, hand sanitizers that were used, that would be used by a taxi industry.
My lady, there's no suggestion there that, well, there's two responses. The first is by 26 June 2020, the Department of Health excluded hand sanitizers from registration, well, from certain requirements of registration. But that came later. It was not at the time of the.
But that's a different registration. That's registration as a medicine, not registration as a supplier of a medical device as required in terms of the SAPRA regulations. It's a different registration.
With respect, my lady, that is not entirely accurate because paragraph B of that notice requires the manufacturer, importer, or distributor licensed in terms of 22C(1)(b) of the Act, listed in the schedules, and so it applies to them. And 22C(1)(b) of the Act refers to distributors of medical devices, not medicines. So
I'll look at it carefully again. But yeah, I'll look at it carefully.
That is why I wanted to just clarify that, my lady. So the tribunal is aware of that.
Just before you move on, Mr. Grobler and Mr. Smith, you didn't deal with this point at all, and I would really benefit from your assistance. Our time is very limited because I'm not prepared to sit for long after 4 p.m. So if you could do so in your supplementary heads of argument, because you've not dealt with this issue at all, even in your heads.
Well, my lady, they did have an opportunity to deal with it, and they did not in their heads of argument, their respective heads of argument.
This is a legal issue. This is a legal issue. I would benefit from the input.
Court pleases, my lady.
That's the court pleases, my lady.
Thank you.
Then I won't spend too much time on the third requirement of CSD registration. The tribunal articulated the rationale for it. It is absurd to have companies registered on the CSD have nothing to do with medical devices and various forms of commodities that could function as COVID-19 commodities, tender for the state for those commodities. With respect to Echo Green's registration, I won't take the court there just because of time, but I just want to give the tribunal the references. And there are 4 important CSD reports which explain objectively, leaving aside disputes of fact, anyway, I should make this very clear. The only disputes of fact that arise on this issue are between Ms. Bimji's affidavits. That is, and we set that out in our heads of argument. I don't mean to traverse the various inconsistencies in her 4 versions. But for now, the objective facts. The first one is a full report uncovered by the SIU. It's at 001746 of case line. 746, which clearly states that Echo Green's CSD report was generated in May 2020. There's then a second report at 001-1899. My learned friend for Echo Green took the tribunal there. All I want to draw the tribunal's attention to is further down the page, where my learned friend did not take you. There is a portion which says bank status not verified. Verification has been sent, but it's not verified. This was at 31 March. Not verified. There's then a third report. The third report is at 001-2131. This report's on 1 April, and there it says, as clear as day, verification of the bank account has failed because it's the incorrect company name. The submission, my lady, is that on that objective evidence, what happened was that the name of the company was changed, and when they tried to verify the bank account, that verification failed. Then there's a fourth report, my lady, at 001-739. And this report confirms that a CSD account for K 2013, the company that Echo Green supposedly did not know about, that was created on 27 March 2020 in K 2013's name. Just refer the court, the tribunal, to those four reports. We submit on that objective evidence clear that on 1st April, that CSD report had been doctored, had been changed, the name had been changed.
Deal with the explanation for these discrepancies.
My lady, sorry, you broke up for a second. If I could just ask you to
repeat. What I would benefit from is your response to Echo Green's explanation for these discrepancies.
So our response to that explanation is Ms. Bimji's first affidavit.
Okay.
And then I won't take the court through all of that, but it's in our heads of argument, and I'm conscious of time. But our explanation, ladies, there was a K 2013 account declared on 27 March. By 31 March, Echo Green doctored that to change the name. And when they tried to verify that bank account, it failed because the bank account didn't match Echo Green's name because it wasn't enough for another company. So that's 31 March and 1st April. And then 22 May, we see Echo Green's actual account was created on the CSD. Those four reports tell the story clearly and objectively without getting into the various contradictions on Ms. Bimji's affidavits and representation. Fourthly, my lady, you raised the issue of Zilwa, this tribunal's judgment in Zilwa, and the concern expressed was that judgment sets a maximum, finds that Annexure A never set maximum prices. And so in this case, our argument that C squared overcharge can't work because Annexure A isn't the right ceiling for a maximum price. And our submissions on that are twofold, my lady. The first is that in Zilwa, what happened was that the SIU, in oral evidence, failed to lead evidence on what exactly the quoted and invoice items were. And so what the SIU did is it said, well, we can just look at these figures generally for a benchmark. And your response, correctly, we submit, was, well, that's arbitrary. We don't know what the product was. We know there are various prices for various products with various permutations. You've got to prove before me which product you're dealing with in order to show that it contradicted the price list in Annexure A. So it was more subtle than no maximum. Your finding, we submit, was that you need to prove, you need to link the product and the price before you can allege that the particular supplier charged more than that price. And so our second submission, as a matter of fact, we have proven here what the product was, and we can link it to a particular item in Annexure A. And lady, the key reference is 001-1242. It's Annexure FA 35.
1, 2, 4, 2.
4, 2.
Okay, I need to have it in front of me when you argue this point.
Okay, 34.
Yes.
And Milady, you'll see this is an affidavit by the supplier of the gloves that C Squared then on-sold to the department. And at 1412, the supplier confirmed that these are latex, powder-free examination gloves for non-medical purpose. And the argument, my lady, is that if you then turn to Table 1, Annex A, Table 1, you find glove.
Page, give me the page number. Where do I find Annex A? Okay, I found it. I don't have the full one, so.
Yes, now we'll
discuss it with you.
I'll ensure that the SIU's attorneys upload the full Annex A. But I will just, if you could just make a note then, my lady, it's item 24. That item.
Okay, go to item 38, 39, 40, 41.
Yes.
42. So the quantity is 100. The quantity is 100.
Yes. And Milady will see that those have slightly different descriptions to the gloves that are referred to in the invoice and the affidavit from the supplier. So, for example, 38 is textured surface and cut off. That's 39 too, and that's a box of 50 gloves for both of those. We then see with 40, they're colored for easy identification. 41 is in sterile packages. But the point is, these items are completely distinguishable from the item that C Squared provide. The item that C Squared provide is in item line 24, and I'm sorry that you can't see that. But if I could just read it out, it's glove examination non-sterile type 1, so made from natural rubber, single-use, powder-free, ambidextrous, one box of 100 gloves. And that is quoted at 49 Rand, 53 cents a box.
How does that differ from item 40?
Apologies, I just closed the item 39. So item 39 has a textured surface and cut off. Sorry, my lady?
Apart from the quantity.
It seems that those gloves, the gloves envisaged there, are textured surface and cut off. I'm not sure what that means, but presumably there's some sort of modification to those gloves, and they differ from the usual smooth gloves that one might be familiar with.
I don't know that. You seem to be testifying now.
No, my lady. I'm making reference to the affidavit from the supplier, where he explains that these are latex powder-free gloves, non-sterile, used for light-duty cleaning, painting, assembly, and manufacturing work. Intricate hand. There's no mention of, for example, cut off or various mutations that we see in Annex A. These are your type 1. Here it is, paragraph 4.7.
Okay, so
latex powder-free gloves, non-sterile. The supplier quote.
The description given by the supplier is very different from the specifications in Annex 1. Hence, I don't understand how you compare.
No, Milady,
that's exactly the point. That's exactly the point in Zilwa. Are you comparing?
I agree.
Bananas here?
Or masks with gloves.
Exactly the point in Zilwa. Exactly.
And Milady, I can only keep saying this. It's unfortunate. Item 24 is the item. It is quoted. It is copy pasted into this affidavit by the supplier. He literally says at 4.7.
I don't have it here. So please, it should be emailed to me, please. And uploaded, please.
I'll ask my attorney to do that immediately. But the point, my lady, is that the SIU in this case has learned from what it did in silver. It didn't just say these are gloves and they were overcharged. The supplier has testified exactly as to which item type these gloves were. In any event, in the supplier's affidavit, it's attached to the founding affidavit of the SIU. It's a Mr. van der Merwe.
Who owns a mining and logistics company?
That is where C Squared got its gloves from, lady.
Okay, I'll consider your argument carefully.
Thank you, my lady. So those are the only points of clarification I wanted to make on the 4 requirements of Instruction Note 8. So that deals with the first half of my reply. But the second half, as I mentioned, deals with remedy. And with respect to that, my lady, there are 3 quick points I want to make. The first is Ledler in paragraph 69. The point clearly says, we submit, that this court, the special tribunal, has the jurisdiction to adjudicate reviews brought by the SIU and to grant an order setting aside an unlawful procurement contract. That to us is quite clear that this tribunal has the power to set aside, to declare as unlawful and to set aside procurement contracts. So that's expressed in the judgment, but then by necessary implication.
I don't have a difficulty with that. My issue is whether it's in terms of the SIU Act or in terms of the Constitution.
And as this tribunal has already intimated, that is an academic question in the sense that it's doctrinal, because it gets us to the same result, whether we are directly based in the Constitution or we're using the powers of 172 through Section 8 of the SIU Act. It makes no difference to the actual powers that this tribunal has. There can be no argument, lady, that the Constitutional Court said that this tribunal can hear legality reviews, but it can't make just and equitable orders in the same way that courts can. There would be very little point, we submit, to legality reviews in that context. Of course, it's not a court, so it's not getting its powers directly from 172, but by statutory intervention through Parliament's legislation, it is getting that power. And that has a necessary implication of the court's finding.
So your argument is that in terms of Section 8, the tribunal can order just and equitable relief.
Exactly, my lady. And the proof was in the pudding in Ledler. Because in Ledler, the Constitutional Court didn't interfere with the SIU tribunal's actual remedy.
But a different reason.
But the point, my lady, is if the Constitutional Court had an issue with the SIU's powers, the tribunal's powers, now that the tribunal is not a court, it would have said something about those powers, would have interfered with what the tribunal actually ordered.
No, it didn't deal. It's quite clear why it didn't deal with that, with the appeal on the merits. It was because that point was belatedly made, and that's why there's a pending case. Grant forfeiture orders.
We understand that.
Different parts represented by the same council. So there's another case coming through the system that deals exactly with that.
But we stand by our primary submission that there's an indirect constitutional link between 172(1)B and this tribunal and that section. The second point I wanted to make about remedy was about the impact of Pomela. And we've heard quite a bit about the principle of no profit, no loss. But what Pomela does, we submit, is just confirm what is quite trite. 172(1)B, this court has a just, courts and this tribunal have the discretion to issue any just and equitable order. And Pomela, the context of Pomela is quite important. What happened there was the SIU approached the court, the High Court, to review a lease. And what they asked for was for all the rent irregularly expended over 10 years, came to about 100 million rand. And the High Court said the lease was entered into unlawfully, but I'm not giving you this money back. It's for various reasons, some of which were too much money, it's irregular expenditure, it's not reflective of profit necessarily, and how long the period was. That's what the High Court says. On appeal, the SIU argues that we're now on TRIBUNAL. So TRIBUNAL says, true discretion, you can only interfere if there's a misdirection in principle or serious misdirection on fact. And in that context, the SIU says, no profit, no loss. That's a principle, a misdirection of which results in a grounds for TRIBUNAL appealability. And it was in that context that the Supreme Court of Appeal said there's no such principle of no profit, no loss. In other words, my lady, just because a High Court doesn't order restitution of profits after declaring a contract unlawful doesn't mean without more that High Court exercises discretion injudiciously under TRIBUNAL. And that we submit is trite, of course. Of course, Fruneman in All Pay and various cases after we submit on a proper reading cannot mean that there's a steadfast principle, deviation from which is a misdirection, an unjudicious exercise of discretion. That cannot be. And if I can just refer the court to Corruption Watch versus Hassana, where Justice Madlanga, for the majority, at paragraph 68, says that there is no preordained consequence that must flow from our declarations of constitutional invalidity. We may make any order that is just and equitable. The operative word any is as wide as it sounds. And it's bounded by two words, justice and equity. That is all. And so we submit what the Supreme Court of Appeal didn't permit us, neither here nor there. Our submission has always been on the facts of this case. It's just and equitable with respect to C squared, and in the alternative with respect to Echo Green to order a disgorgement of profits. The third and final point I'll make today, my lady, is this issue of fraud, and whether fraud in the context of this case justifies a return of the contract price. Now, Echo Green, and we have to agree, point out that in numerous cases, the courts don't actually order a full return of purchase price. And we accept that this may be novel. There are very few cases which actually do this. But there are many cases we submit which find that in the context of fraud, in the context of bad faith, it is possible and it can be just and equitable to order a return of the purchase price without restoring whatever performance was done by the fraudulent contractor. We've got those authorities in our heads of argument. I won't take the court there, but our courts have consistently acknowledged this possibility. And in fact, in All Pay 2, in footnote 47, Justice Fruneman refers to various cases in the context of private law, contract and unjust enrichment, which accept that in exceptional circumstances where there's fraud, you can order a return of restitution that is one-sided. Finally, my lady, we heard quite a bit on why Echo Green is innocent. I think the tribunal articulated why that is mostly irrelevant. But in any event, we just point out that it's hard to believe that Ms. Bimji wasn't aware of the possibility of fraud, that she was an event planner being told to contract for something in which she had no experience. She added, from what we can tell, very little value to this transaction. She was put in touch with the Mr. Shivambu, and she never asked the obvious question, well, why would I end up with this 1.7 million rand contract when I have no experience in this and have added no value whatsoever? In those circumstances, it's very difficult to believe that someone can say, oh, I didn't know that there was corruption here. When with respect, and it's not just lawyer talk, there were red flags and there were obvious signs all along the way, clear foresight, we submit, of malfeasance and maladministration and corruption and fraud, a deliberate flouting of the relevant procurement processes. Lady, unless there are any further questions. My lady, I've just been told that the full notice, practice note 8, with all of its annexes, have been uploaded to case lines, and it was already on case lines apparently, but the full ones are there, so the tribunal should be able to find them. Unless there are any further questions, those are our submissions.
Nothing further from me. When do you When are you
Thank you,
able to
Madam.
submit supplementary heads?
The
Supplementary heads?
end of the week. 2 weeks from today, my lady.
Weeks from today. Do you have a date? Today's the 24th. The 5th of May.
The 5th of May. That's fine, my lady. Fine with us.
Fine with us as well.
I don't know about my colleagues.
That is fine.
Mr. Smith?
My lady, that works for us as well. If I might just ask you to recapitulate what precisely you'd like us to address. I understand it's LEDLA and the SAPRA registration requirement. Is that all?
Yes. LEDLA in relation to, so there's two issues you'd look at, whether this tribunal exercises powers in terms of section 172 of the Constitution, or only in terms of section 8 of the SIU Act, and in the latter case, what approach it should take, because the wording in section 8 and the wording in section 172 is different. So there's no reference to order of unconstitutional invalidity and just and equitable remedy. In section 2, the relevant subsection says the tribunal can make any order to give effect to any ruling it has made. So the wording is slightly different, and whether the jurisprudence that has been developed in relation to just and equitable relief should be applied to when the tribunal exercises its powers in terms of section 8.2. And then the opposing respondents, if they could please deal with the legal arguments regarding compliance with the SAPRA and the exclusion notice licensing requirements.
As it pleases the court, my lady.
Court pleases, my lady.
Thank you very much for your assistance. I've thoroughly enjoyed engaging with you.
Thank you.
And thank you for all the support of you and my lady and my colleagues. It helps. And thank you for indulging me. And thank you for my junior taking over the baton this afternoon.
Yes, thank you for saving the day, Mr. Arons.
For me to recover tomorrow.
You take time. It's my advice to you. Try and take time to recover and attend to yourself psychologically.
I think so. Thank you.
No, not everybody tends to take that aspect of their well-being serious, but it is important to ensure that you are attended to.
Thank you, my lady.
Thank you. Judgment is reserved and the proceedings are adjourned.
Thank you. Bye-bye.
Please.